Hi, my name is Jake. I currently make 5e supplements. They're on my Patreon. I also have a bunch of videos that talk about the things I release. So this is going to be my video on my impression and concerns of the OGL 1.2 talking points, the draft that they've released. There's also a link in the description for the whole 1.2 if you want to download it, and the VTT policy, and also other videos that cover both. So, first off, number 1, Section A, Subsection I, our licensed content. This license covers any content in the SRD 5.1 or any subsequent version of the SRD we release under this license that is not licensed to you under Creative Commons. You may use that content in your own works on the terms of this license. Does this mean that they can simply update the SRD 5.1 in any way they like to require that we now use a separate set of information than we currently used, or than we previously used? I don't know. Section B, works covered. This license only applies to printed media and static electronic files such as EPUBs or PDFs you create for use in or as tabletop role-playing games and supplements, TTRPGs, and in virtual tabletops in accordance with our virtual tabletop policy, VTTs. Does this mean that we still can't create any updating websites like a filterable database of gear or magic items, or a website that allows me to create monsters that are unique for my special homebrew campaign? I love those things. That would suck. Okay, skipping to 6, warranties and disclaimers. You represent and warrant that, letter F, no hateful content or conduct. You will not include content in your licensed works that is harmful, discriminatory, illegal, obscene, or harassing, or engage in conduct that is harmful, discriminatory, illegal, obscene, or harassing. We have the sole right to decide what conduct or content is hateful, and you covenant that you will not contest any such determination via any suit or other legal action. I really don't like that I'm leaving it to the sole discretion of a company to determine what is harmful, especially when they have been harmful with their content. What are they going to do to my stuff? Especially like chainsaw swords. I made that. You can look at that later. Anyway, so number 7, modification or termination. Section A, modification. We may only modify the provisions of this license identifying the attribution required under Section 5 and the notice provision of Section 9A. We may not modify any other provision. So 5 and 9A. Referring to the following section from earlier in the OGL, you control your content. So can they later change how you can control your content? I'm not comfortable with this. This needs to be a lot more specific. Like, give things numbers and letter designations and say, we can't touch this thing, but we can touch this thing. Okay, number 7, Section B, subsection I, termination. We may immediately terminate your license if you infringe any of our intellectual property. Bring an action challenging our ownership of our licensed content, trademarks, or patents, or violate any law in relation to your activities under this license, or violate Section 6(f)(i). We may terminate your license if you breach any other term in this license and do not cure that breach within 30 days of notice to you of the breach. Does this mean that they can cancel any rights you have with the OGL 1.2 if they simply believe that you're saying something harmful or obscene or hateful, or they have their feelings hurt as a company, so they decide to just cancel my use of the 1.2? Or a whole group of people, because they can, technically? They make the determination on this. This is just silly. Be more specific, Wizards. Still, it does seem like a much better legal team. They're more precise, even if it's not precise enough for me. Number 9, miscellaneous. Notices, Section A. We may notify you by any email or physical address we can locate for you. Only if we cannot locate your email or physical address after a reasonable search, notice via a public channel is sufficient. They can change that section anytime they want. They've given themselves a provision to do so. It could then pertain to registering with them if I'm creating something, or giving them copies of what I made for free. Or could they even gut the entire section and have it far more restricting, or say something else entirely? Again, it's just not specific enough. Any section they allow themselves to alter later is dangerous because we don't know what it's going to mean. They're just like, you know what? Or something else. Sure, I'll just agree to or something else. Anyway, letter D under 9, severability. If any part of this license is held to be unenforceable or invalid for any reason, Wizards may declare the entire license void, either as between it and the party that obtained the ruling or in its entirety. Unless Wizards elects to do so, the balance of this license will be enforced as if that part which is unenforceable or invalid did not exist. Is this just giving themselves an escape hatch, get out of jail free card? Like, if we screwed up anywhere here, then we cancel the whole license and anything that's been done for 1.2 is now illegal. That's not fair. I don't want to agree to that. It sounds as though they could determine that you are being discriminatory or obscene as they believe and cancel the 1.2 for you or everyone. Then all the work that anybody or that I have done under it is illegal. It's just, there's no control here. Okay, a couple final points here. G, waiver of jury trial. We and you each waive any right to a jury trial of any dispute, claim, or cause of action related to or arising out of this license. You should never waive your right to a jury. It's a constitutional right. If the judge that you get in a case with them is on the side of corporations for some reason, not just because they were bribed, you would have no recourse, and that's just stupid. H, this one's better. Review by counsel. You should seek advice of counsel to make sure you understand this license. You agree that you had the opportunity to do so. Obviously, I'm not a lawyer, so I'm not advice for this. And how many of us are going to hire a lawyer for this? Yeah, I have the money to just throw away. Hey, lawyer friend, look at this thing. This needs to be better defined. Overall, everything. Because it's too vague, including the termination causes. And also, it's not irrevocable, because they can invalidate it entirely. So that statement they made earlier is just false. WotC benefits from all this because it pushes people to 6th edition instead of 5e. 6th edition is just going to have more features and options because they're preventing other people from using them. I do have to say, though, I feel a little bad for WotC because since they've broken our trust and respect as a community so severely, they're going to have to prove their goodwill or be extremely clear in the new OGL if there is one. This by itself could make it take months. I'm going to give you a few opinions on the statement starting the OGL playtest that D&D Beyond released today by Kyle Brink. Kyle, I just feel so bad for you, man. You're going to get so much hate. And already have been. All right, so we're giving the core D&D mechanics to the community through a Creative Commons license. They already couldn't copyright that, from what I've heard. So that doesn't mean anything to me. And they are really throughout this entire statement fluffing up that they care. They care about our security, our feeling like we have the ability to continue working on what we've been working on, and that we're not going to have to face any hate or discrimination or hurtful things. There are already laws in place to protect people from those things. This is really just to save Wizards of the Coast time and money if they actually do want to address those. But they already can. So that doesn't mean anything to me either. Deauthorizing OGL 1.0a. One key reason that we have to deauthorize, we can't use the protective options in 1.2 if someone can just choose to publish harmful, discriminatory, or illegal content under 1.0. If they choose to publish something that is illegal, they're breaking the law and they'll be punished for it. You don't need to be the police. If somebody's printing something that is harmful or discriminatory and that bothers people, then people won't buy it. Also, it's already illegal to discriminate, so you could have handled that separately anyway. This doesn't mean much at all. In fact, it doesn't mean anything because it's not in a contract. It's not in an agreement at all. It's just, hey, we care about you guys for a page and a half. Take that as you will. That's my impression from listening to a lot of videos lately and lawyers. As I said before, whatever they state, whatever is going to happen, it's going to take a long time. And it's going to go through a lot of revisions. Just pay attention to what's in the actual contract, what you're agreeing to, what they're specifically promising, and they're going to need to be clear, or they're going to need to engender trust in some other way, and I doubt they're going to be able to do that very well at this point. It's easy for people to destroy a reputation online, and somebody did. Sorry, WotC.